Good afternoon. Welcome to the regularly scheduled meeting of the Economic Development and Regulatory Services Committee for today, which is October 9th. I've been joined by council members Fletcher, Cano, Cunningham, and I am positive the other two members of the committee will be here momentarily. But we have quite a lengthy agenda, and so I want to get moving on that. I will note that we have a consent agenda that has a number of items and a few that I would like to either note or make change of. So I am going to first move the consent agenda, which are items number 8 through 20. I will note that these are the regular liquor license and gambling license and business license approvals, as well as business license operating conditions, license settlement conferences, rental license reinstatements, and a number of items that are moving on to public hearings. Before I move to approve the consent agenda, I'd like to ask Mr. Terrell to come forward just for an introduction of a young lady who is doing some incredible work in Minneapolis and Golden Valley that we wanted to give an opportunity to speak this morning. Mr. Terrell, thank you.
Thank you, Councilmember Goodman, members of the committee. I'm Jim Terrell with the CPAD Business Development, and we weren't planning to talk, but we're grateful for an opportunity. This is the item for loan to Cajun Twist LLC, and Tiona Washington, the owner of the entity, is here to speak briefly to this exciting new project.
Great. Ms. Washington, please come forward. I read about you and your path to this point, and I'm just really proud of you and thought maybe you would want to tell everyone what you're doing.
Oh, I mean, so I guess we're just trying to create more jobs for people in the city by way of the Lopez Foundation and the trailhead there in Golden Valley. And I'm thankful that you all are making the changes and adjustments to help us to be able to further that and to be able to take monies designated for Minneapolis and to build infrastructure there in Golden Valley so we can create those jobs.
And perhaps you could just share with folks, kind of, you were in catering and you were doing in your kitchen.
So I started out just doing catering and really just doing meals for my family, and then family members and businesses, they would ask me to come in, bring in pots of gumbo, things like that. And so the demand kind of grew and grew, and so we actually decided to do some research and learn about Minneapolis and the Twin Cities and what people, if they would really receive Cajun food here in Minnesota. And they did, they loved it. We were able, Charlene was one of my first, her business was one of the first to really try us out, and they would have us come in every Friday and bring gumbo and red beans and rice with smoked turkey. And so we would do that. And it grew. The park board found out about us and they called and asked us to come and put in a proposal for the trailhead location. Yep.
Well, thank you for being here today. We're just really proud of you and excited about what you're doing and wanted to point it.
We're excited to feed you guys. So.
Thank you. So with that, I'm going to move the consent agenda, which is items 8 through 20. Are there further comments or questions about those items on the consent agenda? Seeing none, all in favor signify by saying aye. Aye. Any opposed? Those items are approved. With regard to our public hearing agenda, both the public hearing and quasi-judicial hearings, I'm going to move to delete item 7. I understand that the issues surrounding item 7 have been addressed, and as a result, we will not need to revoke that license. Are there further comments about that issue? Okay, on the motion to remove or delete from the agenda item number 7, all in favor signify by saying aye. Aye. Any opposed? That item is approved. We'll then move on to our public hearing. There's only one public hearing, and then we'll move on to our quasi-judicial public hearings, starting with item number 1. Ms. Roberts.
Thank you, Madam Chair. Yes, number 1 public hearing is for Entourage Events Group, Inc., doing business as the Minneapolis Event Center. This business is located at 212 2nd Street Southeast, Suite 225. They are requesting this license, and the requirement of the public hearing is because they're upgrading from a class of entertainment that is Class C1 to Class B. In essence, this will allow the business to provide dancing and DJs at this event center. This application does require a hearing. Notices were sent to property owners and residents within 300 feet. We've received no responses to that public hearing, and lead license inspector Julie Casey is making a recommendation to approve at this time.
Are there any questions for staff on item number 1? Seeing none, we'll open the public hearing on item number 1, which is on-sale liquor with Sunday sales Class B license at the Minneapolis Event Center. Is there anyone here to speak to this issue? Anyone? Anyone? Seeing none, we'll close the public hearing. Councilmember Ellison.
Madam Chair, I would like to move item number 1.
Item number 1 has been moved for approval. Further comments or questions? Seeing none, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. We'll then move on to our quasi-judicial public hearings, which are items 2, 3, 4, 5, and 6. Before we start the presentation, I just want to note this is a quasi-judicial hearing for which this committee is limited by law to hearing arguments from the parties to the matter, consisting only of the city regulatory services staff and the license holder or the license holder's representative. This committee is prohibited from receiving any further evidence or additional testimony. The parties are required to limit their comments to arguments specifically addressing the evidence or testimony introduced before the administrative hearing officer, who previously conducted a full evidentiary hearing in the matter. The parties may not offer, and the committee may not consider, any new or additional evidence that is not already part of the record developed by the evidentiary hearing. The committee has been provided with the record of this matter, including the report and recommendation of the administrative hearing officer. And I also want to just show you the report that we've been given on these issues. And everyone on the committee has had an opportunity to review this report, and it's sitting in front of me for reference today as well. So with that, I'd like to take these items by individual. So we'll start with item number 1, which is the matter of the rental dwelling license at 3115 Cedar Avenue South, and the owner, Jennifer Strand. We'll start with our staff. Mr. Schuckman, welcome.
Madam Chair, committee members, Noah Schuckman, Director of Regulatory Services. Excuse me. I'll give a brief overview of this property. It serves as a summary for all, and I will happily get up and speak to each of them if you'd like, but as all 5 of these are part of the same action and the same hearing with the hearing officer. On December 8th, 2017, the City Council revoked rental licenses associated with Stephen Friends. Chapter 244-1920 of the Minneapolis Code of Ordinances reads, any person who has had an interest in 2 or more licenses revoked pursuant to this article or canceled pursuant to section 244-1925 or a combination of revocations or cancellations shall be ineligible to hold or have an interest in a rental dwelling license or provisional license for a period of 5 years. The denial of these applications was sent on January 18th, 2018 as a result of the property being transferred via contract for deed, meaning that Mr. Friends or his partners maintained an interest. There are at least 4 legal types of interest because of a contract for deed. Ownership. Under both Minneapolis ordinances and Minnesota case law, Mr. Friends and his partners still have an ownership interest in the properties until the contracts for deed are fulfilled. Security. Similar to a mortgage, the property itself serves as collateral under the contracts. Reversionary. If the contract is unfulfilled, the property reverts back to the seller. And control. Mr. Friends or his partners would still have control over sales or ownership of the property were the contract holder to want to make a change. Any of these 4 kinds of interest in the properties would be prohibited because they constitute legal interests in the licenses. There were 4 appeal hearing dates, May 21st, June 25th, June 28th, and July 10th, 2018. The hearing officer's findings of fact upheld the city's decision to deny the rental license applications, and a notice of the hearing officer's findings and of today's hearings was sent on September 17th, 2018. Thank you very much.
Are there any questions for Mr. Schuckman on his report? Are there any questions for Mr. Fussy with regard to the proceeding we're about to enter into? Seeing none, we'll open the public hearing on item number 2, which is a rental license denial at 3115 Cedar Avenue South. Is Jennifer Strand here or her representative? Is Jennifer Strand here, or is a representative of Jennifer Strand here? Last call for Ms. Strand or a representative of Ms. Strand. Seeing none, we'll close the public hearing and I'll move to deny the license. Are there further comments or questions? Seeing none, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. We'll move on then to item number 3. Mr. Schuckman.
Madam Chair, committee members, again, the same summary as I outlined applies. There were 4 hearing dates. Throughout 2018, the hearing officer's finding of fact upheld the city's decision to deny the rental license application, and a notice was sent on September 17th, 2018.
Are there any questions for Mr. Schuckman on item number 3? Seeing no questions, we'll open the public hearing on item number 3, which is a rental license denial at 2726 Girard Avenue South under the ownership of Elizabeth and George Francois. Are Mr. and Mrs. or is George or Elizabeth Francois or their representative here today? Is there anyone here representing the Francois? Final call for anyone representing the Francois in this hearing today. Seeing none, I will close the public hearing and move to deny the license application. Further comments or questions? Seeing none, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. We'll then take items number 4, 5, and 6 together. They involve Kevin McMullen and rental licenses at 2530 First Avenue South, 2532 First Avenue South, 3554 Emerson Avenue South, and 316 Oak Grove Street under the ownership of Kevin McMullen. Mr. Schuckman.
Thank you, Madam Chair, committee members. Again, the same staff report applies. There were 4 appeal dates in 2018. The hearing officer's findings of fact upheld the city's decision, and a notice of the hearing officer's findings and today's hearing was sent on September 17th, 2018.
Are there any questions for Mr. Schuckman on items 4, 5, and 6? Seeing none, we'll open the public hearing on items 4, 5, and 6. Is Mr. McMullen present or any of his representatives present today? Is Mr. McMullen present or anyone representing Mr. McMullen present today? Last call for Mr. McMullen or his representative. Seeing no one representing Mr. McMullen, I'm going to move the staff recommendation to deny the licenses in order in items 4, 5, and 6. I will also note under the consent agenda, we did reinstate a license for Mr. McMullen at 3720 Minnehaha Avenue South due to the fact that we believe he owns the property outright. Are there questions with regard to the motion to deny the rental licenses? Seeing none on the motion to deny, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. With that, we've concluded our public hearings and our quasi-judicial public hearings. We'll move on to our discussion items, starting with item number 21. Kevin, welcome.
Welcome. Thank you. I have the pleasure to come before you twice a year to recommend a slate of projects that are interested in getting brownfield grant funding from our local brownfield grantors, the state of Minnesota, the Metropolitan Council, and Hennepin County. The fall round will have a November 1 application deadline. We encourage people who were interested in seeking this funding to give the city pre-applications. The deadline for that was September 7. We've reviewed those pre-applications. We got pre-applications for 16 projects. 1 project dropped out. That left 15 projects. Of those 15 projects, we're recommending 13. A brief summary of what that includes. We have 8 projects that you've seen before. They've come before you in the past seeking grant funding and are seeking additional funding. 5 new projects. The breakdown of the 13 recommended projects includes 5 that are purely commercial, 7 that are primarily residential in nature, and 1 park project. Of the 7 residential projects, 6 of them appear to be in compliance with the city's affordable housing guidelines. 1 is a purely market rate phase of a project that is otherwise affordable. We did get 4 waivers in this round. As you may recall, you adopted a policy recently that indicated that market rate projects would ordinarily not be eligible for city assistance with regard to getting brownfield grant funding. You adopted 2 exceptions to that for us to consider. Of the 4 projects that sought waivers, we're recommending 2 waivers, and we're recommending against 2 other waivers. We tried to set out as much detail as we thought you might need in the staff report regarding our rationale for both recommending some and recommending against others. I'm prepared to address those in more detail if you'd like, or answer any other questions you might have about this round or these projects.
Are there any questions for Mr. Carroll with regard to his report? Councilmember Fletcher.
Thank you, Chair Goodman, and thanks for this report. Did either of the 2 waivers that you recommended approval of point to modifications we should be thinking about? I know this is a new policy. Obviously in the case of the RBC Gateway, a very small percentage of that building is residential. Did any of this prompt any additional thinking about the policy, or do you feel like we need to see it play out more?
I think there was a lot of thinking and talking about the policy. Most of that was offered by those who couldn't meet either of the exceptions. I've told them that if they've been paying any attention lately, they know how important affordable housing is to the council. Our philosophy is that projects that would otherwise be entirely market rate should consider including affordable housing for a variety of reasons, including the possibility of getting grant funding that they won't otherwise qualify for. I'm hoping that as time goes on and as more and more developers are aware of these requirements, that they'll factor that into their planning process. There are some projects that were perhaps caught a little bit by surprise in this round. We tried to give them as much advance notice as possible. Some of these projects were pretty far downstream, and they've indicated that for one reason or another, either they couldn't or they didn't want to change and try to add units. But this has been a good educational process, I think, for us and for them. And we're talking about people about this on an ongoing basis, and we're hoping that this results in more affordable units in the future.
Mr. Carroll, I did read through each project individually as well as look at the matrix, but I cannot remember offhand, what was the total amount requested within this round?
It's about $8 million.
And the total amount of money available that the city would potentially be eligible for is approximately?
Well, the three grantors together are offering somewhere between $7 and $8 million. The city is not eligible for all of that because each of the three grantors has parameters and restrictions regarding how they can award the money. Of the $4 million that deed makes available, we're theoretically eligible for about $2.6 million if all of the metro area money came to Minneapolis. Often it gets split up, some goes to St. Paul, et cetera. Met Council has about $2.5 million available. They put a ceiling of 50% on the portion of that can go to any one city. In almost every round, we max out at that level. Hennepin County has about $1 million, maybe $1.2 million available. They try to give half of that to the suburbs and half to Minneapolis if they get enough suburban applications. In the last round, we got $6 million worth of grant funding. It's not inconceivable that we could get, 4 or 5 million in this round if we do well. Some projects may not get funded. In my experience, almost every Minneapolis project gets at least some funding. They may not get it from all three of the grantors if they're applying to all three, but they get some. And there are some cases where they don't get everything they want in the first round and come back in a second round and get more.
But in the end, we had 16 applications for $8 million worth of requests, meaning these projects, they either are workforce, business development, or affordable housing will get funding. So we didn't come up with a shortage of products as a result of the mandate we placed on them.
No, we're still oversubscribed, as we always are, which is both good and bad. It means some projects aren't going to get everything they want, but it also means we're going to maximize the amount of grant funding that comes to Minneapolis projects.
Very good. Further questions for Mr. Carroll? Seeing none, thank you for your report. I'll move approval of the staff recommendation along with the recommendations with regard to the waivers and the lack of waivers on the two projects as well. Further comments or questions? Seeing none, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. Thank you for being here today. We'll move on to our final item then, which is setting a public hearing for October 23rd on an ordinance amending Title 12, Chapter 244 of the Minneapolis of Codes relating to housing. And then we will now receive and file, well, first we'll hear a report, then we'll receive and file the report relating to our conduct on licensed premise with notation that we plan to bring forward the final body of work in the next EDRS meeting.
Madam Chair, if I may.
Absolutely. Councilmember, sorry. I was just quiet. Councilmember Cunningham.
No worries. Thank you, Madam Chair. Thank you, everyone, for who is here today for this really important presentation. I just want folks to know that over near the city clerk, we have draft amended language, so folks can get a copy. Colleagues, you also have at your desk a print off of the new conduct on licensed premises process, which we will go over today. And residents can find a copy of all of this information as well on the city's LIMS website. So before we get started, I actually wanted to take a quick moment, if you'll excuse me, Jonathan, but the following city staff, because folks really stuck it out and folks really invested their time and commitment in this complex procedural and policy overhaul. So bear with me, we have quite a bit of folks who have been involved. So I first want to thank Kelly Jones, Rose Lindsay, Noah Shuckman, Commander Charlie Adams, Officer Jennifer Lazarchek, Imani Jafar, Ryan Patrick, Josh Peterson, Sasha Cotton, Gretchen Musicant, Joel Fussy, Jonathan Williams Kenzel, Elliot Payne, Brian Smith, Zoe Borjora, and Wendy Lorenzo Sanchez. Thank you, everybody. We've had a huge work group of folks. I want to give a special thanks to Jonathan and Elliot, who have been serving as co-project managers alongside my office. And last but certainly not least, I want to thank my senior policy advisor, Samantha Priest-Stinson, for her leadership, brilliance, and patience over the last 10 months, not just with this work, but in everything that she has done thus far. So now shifting to the conduct on licensed premises, I decided to step into amending this ordinance and overhauling its implementation because of the high prevalence of conduct on licensed premises calls in my ward. 8 neighborhoods make up 51% of all calls, as we'll hear more about, and a part of 5 of those neighborhoods fall within my ward. I've spoken to thousands of people in my community over the last few years, and this issue is above and beyond the biggest issue identified. I have heard time and time again how ineffective it was in addressing chronic criminal and disruptive behaviors in our neighborhoods, and our crime data demonstrated that much. But the further we dug into the work, the more we learned about how much vulnerable renters were being unjustly impacted by this ordinance, and landlords who were in need of support and resources, which only further solidified the need for this urgent change. So starting in early March, we've been convening this interdepartmental task force made up nearly of all of the city departments, given the complexity of this issue. And what is presented here today is the culmination of that work, in addition to some community engagement that has happened and will happen beyond today. So now from here, I will pass it over to, we have Jonathan Williams Kinzel from the I-Team to kick us off. Thank you.
Good afternoon, Chair Goodman. Good afternoon, Vice Chair Elton, committee members. My name is Jonathan Williams Kinzel. I'm one of the Innovation Team Program Managers, and also one of the project managers for the amendments to Minneapolis Ordinance 244-2020, Conduct on Licensed Premises. Today, some of my colleagues and I, who formed a large working group in May of this year, will be presenting the resulting language changes and desired process for conduct on licensed premises going forward. The outline of the presentation is a recap of the evictions and calls for service report conducted by Civil Rights, system change by the Innovation Team, a presentation of the amendments of conduct on licensed premise ordinance, and tenant protections by the City Attorney's Office, prevention and intervention steps by the Minneapolis Police Department, the enforcement integration steps by the Regulatory Services Department, and we have a list of thank yous at the end. I will now turn it over to Imani Jafar, who will start with a recap of the evictions and calls for service report.
Thank you, Chair Goodman, Vice Chair Ellison, council members. My name is Imani Jafar. I'm the Director of the Office of Police Conduct Review, and I'm here to present to you just a brief recap of the evictions and calls for service report. We actually did present this to the Public Safety Committee several months ago, and it turned out that our commission was looking at the work at the same time that Councilmember Cunningham was already fielding the complaints and looking at how he wanted to address the issue. So it kind of worked nicely that the completion date of the study led it to be the foundation for some of the recommendations and the ordinance change language that you see before you today. So just briefly, the Police Conduct Oversight Commission, which my office is staff for, received from Legal Aid, which is Mid-Minnesota Legal Assistance, complaints specifically about Minneapolis's enforcement of the conduct on licensed premises affecting tenants who they represented. They came to the commission and presented this, and the commission wanted to move forward on a research and study project. Myself, along with legal analyst Ryan Patrick, were the primary authors of that report. And so basically what happened was we looked at a sample of calls for service that ended in the conduct on licensed premises ordinance. And then we talked with both subject matter experts in the community along with city personnel to kind of get a lay of the land for what was happening and what was the police intersection with these calls for service and how was it potentially leading to eviction or a notice to vacate. So basically what came out of the study, and the study is available online. I believe we have a link to it here, and I'm happy to take any questions about that. It's pretty comprehensive, but just to kind of boil it down, first there was management plan. So a management plan is the document that goes out to a landlord who's had a conduct on licensed premises violation, saying that you need to have some kind of plan to address this. Well, previously, management plans were only being given out to the landlord and then community such as block club leaders, but not the actual tenant. So the tenant's first notice of this may have come as a notice to vacate or an actual formal eviction, which is the court filing. A notice to vacate is a lot more informal, can be a letter, can be a conversation sometimes for people. So the other piece is that the enforcement was unintentionally affecting people who actually have state law protections, such as domestic violence protections, which will be addressed later in this presentation, children, and then those with mental health issues. So sometimes the origin of the disturbance or the call may be something that's related to a protected issue, but it wasn't being caught in the previous process. Also, when looking at how were landlords in Minneapolis being trained, the training seemed very focused on if there's a problem, then remove someone, either through an eviction or a notice to vacate, which is much harder to track because it's not a formal court mechanism, a letter that no one would know about maybe except for a tenant. So that's another gap we found too with the data collection is even when an eviction was filed, the city just didn't have data about what happened to people. Were they moving around the city? Were they moving out of the city? Were they becoming homeless? So that was something that we saw gaps in those plans. So at the end of all of our research and study, there's always recommendations on how to address the problems that are found during that process. One was revise the landlord training, make it less focused on legal advice, evictions, and notice to vacate, more on education about being a landlord and taking into concerns some other issues such as equity issues and how to address people, that there are other options other than removal, but not providing legal advice, a more appropriate role for the city. The second was to look at just the process in general for when there's a violation triggered, how is this being delivered? Who's it being delivered to? And kind of accuracy and consistency in enforcement. So both tenants, landlords, and people in the community know when a conduct on licensed premises violation will trigger something more severe, or are there other methods we can do to kind of community build so that maybe people aren't losing their housing as a result of what might be a lower level violation, and making sure, very importantly, that people who are the victims of crime, especially domestic violence, that they're able to have notice that they have protection and not lose their housing when they're going through something like that. The last recommendation was improving data collection. So making sure that if in the end, which there may be situations that it's completely appropriate for a landlord to say this situation is not salvageable, we need to end the relationship, that if they're given a notice to vacate or they're evicted, that there is some data being collected on what's happening as a result on the conduct on premises. Or if there is something negotiated in the interim, that you can know if that's successful, if there's city programs. And also just that way the city after an amount of time can look at that data and see how is this process working? Is it an improvement from what we had? So that's kind of just a very boiled down version of the study, but if you do have questions about it, I would be happy to answer those. And at this time, I'll actually turn it back over to the innovation team.
Let me see if there are any questions for you before we move on. Are there any questions? Okay, seeing none, we'll move on to the next portion.
Thank you.
Hello, Chair Goodman and Vice Chair Ellison, rest of council members. My name is Elliot Payne. I'm a designer on the innovation team, and we wanted to talk about how we took the study out of civil rights and operationalized that to create changes within the ordinance. And the first thing that we had to do was get an understanding of the existing the previous process. And what system change is about understanding the outcomes that a system is providing, and we want to look at those outcomes and see if that's the outcome that we desire versus the outcome we're achieving. And we saw from that study that we weren't achieving the outcomes that we desired, and in fact the outcomes were disparately impacting parts of the members of the community. And a lot of that comes down to, the decision-making process around this ordinance and how that decision-making process was somewhat opaque, and it was mostly managed by a sole individual, of which that workload left a lot of opportunities for these disparate impacts to happen. So we approached this with some principles around systems change, and I'll just describe these really quickly. One of those is just to understand the needs and the assets of the system. Who are all the actors that are operating in it? What are those decisions that they're making? We just need to map that all out so that we can start engaging with the right people that are involved. So that's principle number 2. Principle 3 is visualizing that, all of those interactions in a process diagram or flow, doing it together. So we've had a lot of people that Councilmember Cunningham has thanked at the beginning of this that have been involved. We've also engaged a lot of the people who have been impacted by this ordinance, including landlords, tenants, neighborhood associations. Another principle is distributing leadership. So, no one person can drive all this. Councilmember Cunningham's had a lot of leadership from the position of being a council member, but we've also had to have leadership from all the various departments involved as well, and all of those have been contributing to these better outcomes that we're hoping for. We want to foster this culture of learning, meaning that today is the beginning of this process. It's not the end of the process, and so that's going to go into continuing to engage with community and continuing to evaluate those outcomes so that at the end, we want to align the actual outcomes with our desired outcomes. And that's just a quick summary of our approach to doing this work.
Okay. Mr. Fussy.
Thank you, Madam Chair and committee members. Joel Fussy from the City Attorney's Office. I was assigned by my office to work on this matter. And the slide that's in front of you now in the City Attorney's portion of the presentation illustrates just some of the changes that were made in the amendment draft throughout the process after multiple staff meetings and some stakeholder input. But I think more importantly, I'm going to be focusing on just a brief overview of the full text of the ordinance amendment, which is linked on the online council agenda. First and foremost, if you look at the amendment text itself, you'll notice that contrary to maybe some information that was out there, the conduct on premises ordinance is not going away. And in fact, much of the previous ordinance remains in this draft, including the retention of the same 7 categories of qualifying incidents. Those are listed on the first page of the ordinance draft, and they remain the same. They include on-premises activity ranging from prostitution and sex trafficking to unlawful sale or possession of narcotics and weapons, noisy assemblies, disorderly conduct, and illegal gambling or alcohol sales. And then as you just kind of walk through each of the sections real quickly, subsection A does include a new purpose statement stressing the desire to discourage unnecessary tenant displacement while at the same time effectively addressing and preventing instances of disruptive criminal and nuisance conduct. It also makes the entire program less, I guess the term would be MPD-centric, and it instead establishes that the program will involve multiple departments working with regulatory services and even the involvement of some outside entities and programs in the process. In subsection B, it merely kind of reiterates that collaborative administration and enforcement responsibility. That's at the top of the second page of the actual ordinance draft. Subsection C gets into the specifics regarding the notifications, and those are commonly referred to as the letters that went out. And the big change in this section is that the notifications will now be made to both the landlord and the tenants when a qualifying incident occurs, so that the tenant is going to be aware much sooner than previously of a qualifying incident. And this is work that is going to be carried out by all of the CPSs now, as opposed to being the responsibility of a single individual. And another important change is that under these amendments, The notifications need to be based upon an actual Minneapolis police report. I think there was some concern expressed that some of the previous letters were based upon less reliable data sources. So there was a desire and a directive to focus on actual police reports, documented police reports. Moving on, subsection D reflects probably the biggest change in the new process or the new amendment, and namely that's the use of what is being called an interdisciplinary review panel to intake and review all of the qualifying incidents that get forwarded from the CPSs. The panel will be housed and convened by regulatory services, but it may also contain representatives from the health department, the city attorney's office, other appropriate city staff, and also representatives from public or private community business or social service organizations. The panel is envisioned in the ordinance to operate informally and in collaboration and by consensus, with a backstop provided there that in the event that consensus can't be reached on an individual determination or recommendation, that the Director of Regulatory Services is able to make that final determination as needed. Then briefly, the panel can kind of funnel the cases into three separate courses that they can take. First, they can review the file and determine that the incident has been resolved at, the CPS level or before it got to them, and the property's inclusion then in the program would be terminated subject to possible reentry if additional qualifying incidents occurred. Secondly, the panel could designate a property as being subject to additional monitoring by the CPSs for a period of up to 1 year, and the landlord or tenants could be offered any appropriate identified services, resources, or referrals. And lastly, would probably be a smaller subset of cases, but the property could be designated for what's being termed an intervention plan, and that intervention plan may impose required actions to be taken by the landlord, including any number of things, and they're not limited in the ordinance, but they could include things such as participation in designated meetings or training, submission of incident response plans, kind of a different version of the management plan that you may have heard of before. And of course, a lot of work is going to be done on what might be asked for or contained in those incident response plans. The imposition of formal conditions on the landlord's rental license, which is an area of enforcement that regulatory services previously was already in the process of implementing, but I think that the idea is to fold that more seamlessly into this process. And in cases which might rise to a specified qualifying level, the more serious cases, there remains the potential for revocation or denial of the license. A landlord would have the ability to appeal any mandatory aspects of an intervention plan, including any conditions imposed on the license or any adverse action proposed to be taken against the license. Next, I want to talk about subsection E, which is separately discussed in a few slides in the presentation, but really is the work of Councilmember Schrader to more affirmatively and directly address tenant assistance service calls. That work has now been merged into this ordinance amendment that's in front of you, and the language you see in that subsection E, which for the first time specifically incorporates the state statute that's entitled Residential Tenants' Right to Seek Police and Emergency Assistance, it incorporates that into the Conduct on Premises Ordinance. And that statute, combined with the new and specific language in the amendment, will clarify and establish that city staff will not pursue any adverse license action in instances that involve tenant assistance calls, which commonly arise in instances of domestic violence, but can also arise in health-related or other emergencies. Conversely, a tenant may not be retaliated against by a landlord for such tenant emergency assistance scenarios. And as I did mention, that work was really brought forward by Councilmember Schrader, and I guess I would defer to him if he had any other comments he wanted to make.
Madam Chair, great. I'll be really brief. Just wanted to really just say that they're really proud of the kind of the work that we've done. This issue came about because we had constituents coming to me with this very issue, and advocates saying, we need to have some change in the law. So I'm proud that Minneapolis is really leading on this forefront to put specific wording in our city code to reinforce our commitment to survivors of domestic violence, residents struggling with domestic illness, as well as anyone just trying to use 911. No one should really have to choose between receiving emergency services or having a safe place to live. In closing, I just want to thank Luke Grundman and Georgina Santos from Minnesota Legal Aid. Eric Hoggy from Homeline, Minnesota, Jennifer Arnold from Inconitos Unidos, Standpoint, Minnesota, the Domestic Abuse Project, and I also want to take this opportunity to, of course, thank Councilmember Cunningham for really working on this. It didn't take long working on just this very specific part that we thought would be a kind of a technical way to help advocates to see that the whole thing needed to change. So I want to thank you for your leadership as well.
And thank you. I do have just a couple brief remaining comments in my section that I'd like to work through in the overview here. Subsection F of the amendment, continuing on, speaks to, in large part, to some of the data tracking issue that Ms. Jafar spoke of just before me, and and it also establishes a city policy to refrain from encouraging or being involved with the evictions. It requires that landlords subject to the Conduct on Premises program must report any eviction actions or the less formal notices to vacate issued in response to qualifying incidents or throughout the process. And it establishes, and this is just quoting the language, that shall be the policy of the city to refrain from encouraging or directing the eviction, vacation, or displacement of any subject residential rental tenant as part of the Conduct on Premises program. Instead, such action shall be entirely in the discretion of the licensee and shall be undertaken in strict conformance with all applicable laws. And finally, subsection G just codifies that provision I spoke of earlier that states that a formal police report must be used in making any determination that a qualifying incident occurred. And that would conclude my part of the presentation. Certainly, if any questions are there, we could address them now or when the chair feels appropriate.
Go ahead.
All right. So I'm going to begin to talk about the new process that we've developed. I will talk about the prevention intervention part that will be overseen by the Minneapolis Police Department. The application of conduct on licensed premise will revert from a centralized program to a decentralized community-based approach with crime prevention specialists at the precinct level responsible for prevention intervention. While the centralized process made MPD accountable for determining qualifying incidents and monitoring the compliance of management plans, the community-based model will no longer have MPD solely responsible for monitoring and compliance. Through prevention efforts, CPSs will have the opportunity to work with tenants, landlords, and residents to build awareness regarding the ordinance's goals, provide guidelines for how incidents will be addressed, and explain how qualifying incidents are determined. During the intervention stage, the CPSs will review police reports and upon careful review, determine if an incident can be deemed a qualifying incident under the ordinance. If any qualifying incident is determined, the CPS will issue a letter to both the landlord and the tenant, with the tenant receiving a copy of the letter that the landlord received. Once letters are issued, the landlord and tenant will be provided the opportunity, but not requirement, of 10 days to respond to the letters they receive. Depending on the incident type and the information provided, we hope that the tenant and landlord can resolve the conflict or resolve the incident without further intervention from MPD, and the tenant can remain in the residency. In the event the city does not receive a response or additional qualifying violations occur, an interdisciplinary panel will receive the CPS's effort and determine if further intervention actions are needed going forward.
Good afternoon, Madam Chair, members of the committee. My name is Kelly Rose Jones. I'm the Director of Housing Inspection Services for the City of Minneapolis with Regulatory Services. I'll give you a brief synopsis of the second half of your process flow chart involving enforcement and integration. As Joel mentioned, a large part of this new process is going to involve this interdisciplinary review panel, which will be convened by Regulatory Services, and we will be doing the logistics of setting up meetings, taking notes, et cetera, making sure that process flows. But once an incident is unresolved by the crime prevention specialist, it will move to the interdisciplinary review panel, although the review panel will be looking at all incidences that qualify in order to understand and monitor them as they go. The review panel, again, will determine if it's a low or high priority. Once that's been established, the low priority items will continue to be monitored by the crime prevention specialist for a designated period of time. The incidents or the situations are determined high priority will have a deeper look by the panel and may require the development of an incident action plan or some other mitigating plan that will help ensure the problem is resolved on behalf of the community, but also engages the landlords and the tenants in that action. Also, as stated, the panel may also, if it's severe enough, recommend conditions on the rental license or that the license be revoked. All of these may be appealed and will be appealed through the standing hearing appeal process structure that's already in place. So the integration phase is, again, a place where we will be continuing, the panel will be continuing to monitor the activity in cooperation with the CPSs. And if no additional incidents occurred during the specified time, the case will be resolved and considered closed. If another qualifying incident happens during that period of time, monitoring time, it will be referred back to the panel, who will then make additional recommendations or decisions about how to move that forward. And then finally, another piece of this program is the continual monitoring and doing the data analysis. The IT team has done a great job at identifying specific data points that will be collected during the process so that we can always look to make sure that we're meeting the outcomes of the process and protecting community and tenants and making stronger policy. And with that, I think we're done with the presentation, other than the thank you for all the people who worked really hard on this.
This is the full process that you have in front of you all.
And I took the second half.
So this is the list of thank yous and the groups that we worked with. I think we did some thank yous up front, so I'm going to leave the floor to any questions that we may be able to answer for you today.
Are there any questions for staff with regard to their presentation? Councilmember Ellison.
I just wanted to thank staff for all the work being done. I might sound like a broken record, but to echo what some of my colleagues have said, I've also faced a number of mainly landlords who have said that they have felt like their hands are tied in instances where they've had to evict tenants, and they felt like they otherwise wouldn't have. And so hopefully we're equipping folks to be able to stabilize their tenants, stabilize their buildings, tenants to be able to stabilize their lives. And I'm really thankful for the work of my colleagues and the work of staff. So thanks.
Further comments or questions? Sorry, Councilmember Cano, followed by Councilmember Fletcher.
Thank you, Madam Chair. I just wanted to share that I did get a chance to meet with staff briefly on this effort before it was brought forward today. And my one piece of feedback was to ensure that we have the multilingual communications aspect of it down so that when letters, because I think what I really appreciate about this, there's lots of things, but one piece of it that really spoke to me was the clarity, seeking more clarity in how we communicate to the multiple impacted people that are involved in responding to an incident like this or a potential incident, is to ensure that that communication is clear, that all of the folks who are impacted are engaged and aware of what's happening. And so one piece of that was just to ensure that we have Spanish, information in Spanish and Somali and Hmong, and perhaps the other, whatever comprised the top 5 languages in the city at the forefront, instead of waiting for people to call to request it, that we're just proactive on that front, and that's included in the letters that get issued out. And we looked at the spacing layout, and it looks like there is enough space to include in that introductory letter just a little blurb in Spanish and Somali and Hmong. So I really do want to thank the council members who took this work on. It's really nice to see such a strong package of ideas and recommendations that are well supported by staff coming forward. So this is amazing work, and thank you to everyone who took it on.
Thank you, Chair Goodman. I just wanted to thank my colleagues who worked on this and the city staff. This is something that in Ward 3 is mostly going to have an impact on student housing. And we've seen a lot of instances where an incident might occur, and obviously we want to have a process. Students throw parties, it turns out, and we want that to both not be a chronic thing that drives the whole neighborhood nuts, but also not have people getting kicked out of their housing and treated unfairly. And I think that this process looks incredibly well thought out. When I first saw this process map, I thought, oh my gosh, are we making this hopelessly complex? But actually, as you walked through it, it really looks logical and reasonable, and like something that people can follow and make sense of. So thank you for the work that everybody put in on this. I'm very supportive of the outcome.
Councilmember Cunningham.
I just thank you to everybody again, and also thank you to my colleagues who have been active in learning more about this process, and to the community who have been involved. We actually did. Could you take a moment to talk about the community engagement that has been done and what will be done moving forward?
Yes. So in August, we met with the impacted stakeholder groups. So we met with tenants and tenant advocacy, landlord groups, and neighborhood associations. We met with them, went through a series of exercises explaining the process, and also give them the opportunity to discuss the framework of the level of intervention that would be necessary for an ordinance like this, and gave them the framework of, we want to keep people in their homes as much as possible, but how do we do that and operate in a system that also protects and respects the conditions of neighborhoods and as well, and respects also the landlords and their properties as well. So it's a very finite box to put in, but we got some good information out of there that will help us moving forward, not just on the policy language, but procedural and some behavioral changes that will have to go on within MPD, regulatory services, and some of just the work we're gonna have to do in neighborhoods as well. From there, last week we had a community event at Thor in the Copeland History and Arts Gallery. I just learned the name last week, so please forgive me. We had that on last Friday from 5 to 7. Going forward through this process, as we move into implementation, we will be actively working to engage these stakeholder groups continuously as we refine some forms and some modules and some different pieces of information that will make landlords and tenants have the ability to provide input in a very uniform way, and also help our CPSs be able to break down information and determine what a qualifying incident would look like going forward. And this is just a continuing process of learning, and we put that in the actual process of continuing to learn, to continue to evaluate this program, and to make sure that we address our needs. And through engagement and continued engagement, we'll be able to refine this and make changes as our community can changes in the future. So.
Thank you. And in closing, I also just want to make sure that I take a moment to thank Councilmember Schrader. When we talk about the most vulnerable folks who are impacted by this ordinance, we're talking about folks who called for help a lot of times, who ended up that being negatively impacting their housing situation. And so really to call that out and focus on it is just, I thank you so much for your leadership on that. And I'm glad that we were able to pull it all together and really, like was said, pull together a strong package. So thank you, everybody.
Thank you very much for your report. I did have an opportunity to spend an hour and a half or so just understanding how the current process works and the things you're doing to make it more equitable and fair. I'm extremely impressed with the work that's been done on behalf of staff, as well as the leadership of council members who have taken this on, including council members Cunningham and Schrader. I want to thank you on behalf of the enterprise for everything you're doing, and we appreciate the way this has come forward with the briefing today, followed by a public hearing on the 23rd. So what we need to do today is set a public hearing for the 23rd, as well as receiving and filing the report. Councilmember Cunningham, would you like to make that motion?
Yes, prior to the motion, I just want to have residents know that as mentioned, we will be setting the public hearing for the next 2 weeks. Please take the time to review the language and the materials that all of that is posted with today's agenda, and to send emails with feedback to Ward 4 at minneapolismn.gov. And with that, I motion to receive and file, or is this?
Set a public hearing.
Set a public hearing as well as receive and file this presentation.
On the motion by Councilmember Cunningham, are there further comments or questions? Seeing none, all in favor signify by saying aye. Aye. Any opposed? That item is approved. Seeing no further business before us, we are adjourned.